Hi, I'm Carol Roberts, the Community Resource Development Agent for the University of Florida IFAS Extension in St. Lucie County. Today we're going to talk about estate planning. We're just going to go over some of the basics of some of the estate planning tools you might consider using once I convince you that you probably have an estate and you might really want to plan for what will happen upon your death to those assets and minor children that you might be responsible for. So let's get started. So what exactly is estate planning? It's just thinking about what will happen to your property during your life and upon your death, and who will take responsibility for those things. So it's a plan to transfer your assets or make decisions about those assets if you become incapacitated and can't make those decisions yourself. And it's a plan to care for any minor children that you are responsible for. So it just involves a little bit of thinking about what could happen and what we want to make sure happens if we're not there to make the decisions that we usually make for ourselves. And you might ask yourself, what exactly is an estate? I used to think I didn't have an estate, but I have since learned that I must be one of those wealthy people. I have an estate. So what is an estate? Well, those are your assets. If you've worked to build a retirement account or a pension with a company, that would be an asset that you want to plan for the use of. If you've purchased any real estate, a home or land somewhere, that's part of your estate. That you want to make sure the transfer of that real estate is taken care of when you are not available to do it. Did you know if you have a checking account or a savings account or any kind of investments, you have an estate? And we'll talk about some different tools for transferring those bank accounts when you're not available. Also, if you've ever if you own a car or any type of motor vehicle, that's part of your estate also. You have a title for that item, and the state says they need to know where that title should be transferred to. Other parts of your estate involve family heirlooms or any jewelry or other items of value that you have a definite idea of who should take ownership of that when they're no longer in your possession. Well, that's part of your estate, and you can take care of all that with the different estate planning tools we're going to talk about. So who needs to plan their estate? Well, based on what we just talked about, sounds like pretty much everyone. But let's be a little more specific. Anyone who owns an asset that they want to make sure becomes the property of a specific person or organization upon their death has an estate plan. Now, I say that because if it doesn't matter to you what happens to your property upon your death, you can leave it up to the state to decide. That's called probate. And we'll talk about more specifically about what probate is and what it means. But also if anyone with a minor child or children whose care they prefer to choose in the event of their own death has an estate plan. One example I can think of is a cohabitating couple who may be raising children, but one of the children may not belong, one or more of them may not belong to both of the couple. If one of those children passes, according to the state probate, the next person in line would be the other parent. What if that child has never met their other parent? I know a family that this would be a situation. So if something were to happen to that mother, the state would pass that child along to the father who they have never met before. So if it matters to you who your minor children would be assigned to in the event of your death, you might need to plan your estate. Now that you understand you probably have an estate that you need to plan, how do you get started? Well, there are 3 steps to getting started in your estate planning journey. First, set your financial goals and your objectives. What do you intend to plan for? Do you want to plan for your incapacitation, or just for what's going to happen after your death, or both? Do you want to make sure that your family is taken care of with a windfall of money in case you, the breadwinner, are not there to earn it? Or maybe there are lots of different ways to focus your financial and estate planning. So set those financial goals and identify those objectives, and then communicate with your family and about what those objectives are. Collect the information that you're going to need to use those different tools that we're going to learn about, and maybe even start investigating which professional advisors you might use to review your documents or help you plan. And complete the appropriate paperwork on your own or with that professional advisor. But however you choose to plan your estate, you might plan to spend a little bit of money so that you can make sure that those legal documents are actually legal and filed properly. So this is a worthwhile expense, but we will talk about different ways to keep those costs as low as they can be. Now we're going to look at some estate planning tools that you might consider using, and this is in no means a comprehensive list. There are other tools that you might consider, and other aspects of the tools we'll look at. But keep in mind that all of these tools will have tax implications that you might want to speak to a financial advisor or an accountant about as you establish which tools you're going to use. Look at the implications and how it's going to impact your family upon using these tools. So let's look at all the different tools. One of the most common estate planning tools that people are familiar with is a will. You know, they say where there's a will, there's an heir. And all a will is a legal document that dictates how to distribute your property after your death. And this, you can find the standard forms available online. Just Google the words will and single mother or married couple, no children, and you can find standard documents, fill in the blanks that you can use to help build that document for you. If you die without a will in place, a valid will in place, that's called dying intestate. And that means that the state will determine how to transfer all of your assets, and your minor children, according to state law. We'll explore probate a little bit more in just a moment. So the cost is going to vary depending on the complexity of the document, how many assets you have to transfer, how many children you might be transferring to, and how involved that transfer might be. But basically, if you can find a standard document and fill in the blanks yourself, then you can take that document to a professional for a review and pay a small fee. And that can help you save money as you develop your will. Make sure that when you choose a will, you're going to name an executor, someone who actually will carry out the wishes that you explain in the will, and you might have to assign a guardian for any minor children that you have. As you do that, communicate with the people that you are selecting for those roles to make sure that they are willing to accept those roles and are aware of where to find the documents that prove that they are named in your planning. Joint ownership is one of the most common ways to transfer an asset upon someone's death. It simply involves adding more than one name as an owner on a title or an account. So very simple, 2 names, 2 owners, one of them passes. The surviving owner takes full possession of the asset. So very easy and free. But there are some disadvantages of this estate planning tool. A co-owner A named co-owner has immediate access to your property. So if you put both names on a bank account, both people have access to the contents of that account. If you put two names on an automobile title, think about the word that joins those names. It matters to the state. If you put the word or, either one of those owners could sign away that title to that automobile without the other's permission. Only one name would be necessary to sign the title away. If you put the word and, both people are necessary. Both people's signatures are necessary to transfer the ownership of that automobile. So think about that little word in between the named owners. Also, if you name a co-owner who is a non-spouse, it could trigger a gift tax consequence. And we're going to talk about the gift tax in just a minute, or the gifting in just a moment, to explain that further. And a co-owner that has debt problems could cause creditors to go after the co-owner's share. So if someone is named as a co-owner and they owe money to a debt collector who has permission to access that account, can take that money from that debt collector can take that money from the account. So be careful who you name as a co-owner and understand their financial responsibilities before assigning them co-title. Also, one caution is, like I said, a co-owner has full access to your accounts at assets at any time that they are owner. So you want to consider that consequence. Leaving all your assets to your spouse may seem like the easiest in the short term, but by doing so, you may miss the opportunity to use the estate tax exemption, and instead you'll increase your spouse's taxable estate. So this is a common way to transfer ownership, but maybe not the best way. So that means your children are likely to pay more in estate taxes if your spouse leaves them the money when he or she dies. Plus, it does defer the tough decisions about the distribution of your asset until after your spouse's death. So those decisions that you don't want to make, you can use joint ownership and delay those decisions and put them on someone else. But if you want to take responsibility and make those decisions yourself, you might choose a different tool than joint ownership. Just mentioned gifting, so I wanted to explain what that is. And that's just the donation of your asset to someone else other than your spouse. So it could be a child, a family member, a friend, or an organization that you're leaving money or property to as a gift. But the one thing to consider is that gifts that are valued at over $12,000 are subject to a federal gift tax that has to be paid by the donor, meaning your estate. So if you're gifting while you're still alive, you might want to make sure you know what the tax implication will be, and you can face that but it is an effective way to transfer your assets to other owners while you're still alive and remove those assets from your possession. Another tool you might consider is the beneficiary transfer. That just means that you assign someone to receive that monetary gift upon your death. You become the benefactor to the beneficiary. So life insurance policies, pensions, and trusts all should have a beneficiary assigned. And the nice thing is, you can assign a secondary beneficiary. You can even split the assignment of the gift, the beneficiary package, in a percentage to more than one person. So it is a really nice way to transfer a monetary gift. That pension that you worked so hard for all your life could be assigned to someone or more than one someone else. Also, and again, just like with most of these planning tools, review the tax implications so you can make the best decision for yourself and your family. One tool that can help you if you become incapacitated or die is a living trust. And that's just an illegal arrangement that gives control of your properties to someone else in either of those situations. It's similar to a power of attorney, but it can be designated as revocable. So if you consider that you might be incapacitated, however, it might be temporary, you can designate your living trust as revocable and take control back from your executor when you are in a place where you can manage that again. So you will assign a grantor, a trustee, and a beneficiary for your living trust, and they can all be the same person, but make sure you assign a successor to take control of those assets upon your death. Also, just like with a will, there are standard forms available that you can Google, print, and fill in the blanks and take to a professional for review and to find out how to file it and make sure it's legal. But a living trust is a document that says you assign someone you trust to make the decisions that you are no longer able to make. But a living will is not the same as a living trust. Like I just mentioned, a living trust says you trust someone to make those decisions. With a living will, you are making those decisions yourself and documenting it in print. So it spells out your medical wishes about being kept alive if you are terminally ill or seriously injured. A healthcare proxy or a medical power of attorney, by comparison, is a document in which you name someone to act as your agent to make medical decisions for you in the event that you're unable to. So the other tool is for letting someone else make the decisions, someone you trust carry out what they know you believe, or the living will is where you just tell people what you believe. And standard forms, again, are available for this. A notary is not required to make this a valid document. In fact, you only need 2 disinterested witnesses' signatures on a living will for it to be considered legal and binding. So very easy to complete. And there's an organization you might look to. 5wishes.org is a not-for-profit organization that provides a living will document that you can buy for $5 for 5 wishes. And it asks some very pointed questions and allows you to choose the level of care that you are comfortable with. It has the signature lines for those 2 disinterested witnesses' signatures and your own, and it becomes a legal and binding document once it's been completed. So a living will is a good idea to have in place and very easy to do. 5wishes.org is a great place to find that standard form and support a not-for-profit organization. Just to touch on, some of us may be familiar with the name Terry Schiavo. That was a very emotional legal case here in Florida several years back, in which a husband and a mother of a person who was injured were in dispute about what her wishes would be. The medical professionals were saying that she would not recover, and her husband was saying that she had said when they were out dining one day that she would not want to be kept alive in such a situation. Her mother disagreed. If they had grabbed a napkin during that conversation and asked any of the 2 people in that restaurant to sign her saying, "I would not want to be kept alive in that situation," they could have saved a long and arduous legal battle from happening. So you can be as cavalier as that, or you can go to 5wishes.org and really get down to the nitty-gritty about what level of care you would accept or not accept in a situation where you weren't able to make that decision yourself. So all those tools that we just talked about are to help us avoid probate. Probate is a legal process where the state gets involved in your final moments. The state conducts an inventory of your personal property. Using your assets, they pay any legal debts that you have and distribute any of the remaining assets and property according to state law to your next of kin, and they have a hierarchy of how they decide that. Your minor children also fall within that hierarchy. If the next of kin is not someone that you would want to raise your children, like I said, you may need to plan that estate. So probate, if you die intestate without a will or any kind of estate planning, it can be very costly and time consuming. I mean, we all know the government doesn't do anything fast, right? So, and there are fees involved in processing a probate case. So it will be a faster and cheaper process if you have plans already outlined when you are gone. One thing to keep in mind once you've completed all those documents is that life happens and things change. So we may need to make modifications every so often to those documents. We have to face our mortality again for just a moment, maybe every 5 years or so, or if we've had a change in the size of our family, maybe we've lost members or added, that may affect our estate plans. If some member of our family has become dependent or disabled and they weren't before, that may change your estate plans, so you might need to modify them. Oh, if the tax laws change and the tax implications from those tax law changes are going to affect you, you want to know about that and take steps to mitigate those changes, any negative effects of those tax law changes. And any changes you make sure that those who are affected, those people who are mentioned in your plans as beneficiaries or who will receive your transfer on death of your bank account, make sure those people know of the changes. If they've been removed, let them know. If you've added someone, let them know. It's important. We've seen movies where people were not aware of assignments in wills, and you know, it's entertaining, but it's not really fun in real life. Our conversation would not be complete if we did not discuss final arrangements. You can, in fact, make advanced arrangements for your final service. And it's a good idea to do so because it saves your loved ones from having to make those difficult decisions while they're grieving for you. You're important to them and they are going to miss you. It's not the best time to be making financial decisions and being targeted by salespeople who work for those funeral companies. So if you can make those decisions for them, it allows them to grieve peacefully. So it also helps to ensure that your wishes are met. If you have a specific desire for a song or a scripture, or like the inventor of the Pringles can, you want to be buried in a Pringles can, all those kinds of wishes that you might have need to be in print somewhere so that your final arrangements are carried out the way you would like them. So if you search in advance for your final arrangements, it allows you time to research the best values because you know what your grieving family is not going to comparison shop for your casket. They're going to go with the easiest arrangement they can make while all the family members are driving in from all over the rest of the country, right? It's not a good time to make good financial decisions. So if you are interested in making advanced arrangements, you'll find that many funeral providers do offer various packages, and you can compare those packages and even make payments and prepay for these these arrangements. But keep in mind that you have the right to buy any of those items separately. You are not required to opt for the whole package. And you might consider that some things you're charged for are not legally required. They're just kind of niceties. You can make the decisions on what you really want to have happen. And so compare prices on those separate goods and services. So you're comparing apples to apples when you're looking at packages, and then know the legal requirements and your options for those different services. Lastly, once you've done all that planning, faced your mortality, you will have a lot of paperwork to care for. So you want to make sure that you're storing those documents properly in a place that is fireproof, maybe waterproof. Consider a grab-and-go storage container for those times when we have to run from a hurricane or a tornado, some sort of natural disaster. You can buy a fireproof, waterproof little briefcase at your local big box store and put all those important documents in that one case to grab and go. Another place you might consider storing your important paperwork is virtually in the cloud. You might scan and save it all to a flash drive that you can grab and go, or upload to a cloud that you can access from anywhere in the world where you might need to relocate to. You can store them in a safety deposit box at your local bank. Then they're safe and secure there. There's a minor fee involved, but then you can tell the bank who has access to that deposit box upon your death so they can access your paperwork. You might put a copy in a safe place at home or in that briefcase to grab and go, but make sure that it is available in some way so that the people that you've named in those documents know where that location is and they can get to it when they need to. A lot of important paperwork. And you want to make sure these important paperwork that may have identifying information on it is also protected from someone who might take that information and steal your identity with it. So be careful where you store that important paperwork. All right, we have faced our mortality and we have addressed these issues, and we are ready to become immortal again because, estate planning, it's a time-consuming process that's laden with complex decisions and a lot of emotions that are associated with our facing our mortality. But, no one's going to force you to do it except yourself. And once you realize how important that is to plan for the transfer of all that hard work you put in during your lifetime, you will be motivated to force yourself to plan your estate. And then you can get that plan in place and get back to being immortal, enjoy life, and worry less about the future. Thank you for joining me. I'm Carol Roberts, the Community Resource Development Agent in St. Lucie County. I'm going to leave you with a list of resources that will help you to plan your estate, and check out the Federal Trade Commission. They have some really good consumer guides on estate planning tools and how to make sure you're using reputable providers and getting the best buy. Lots of good resources for you. Have fun, and thank you again.